What shows up in court after a security breach isn't the exploit. It's your patch history, your training records, and whether you knew where that sensitive data was. I talked with Mike Jervis, a cybersecurity lawyer who's called in after security breaches. He's the one companies call when they're locked out of their systems and facing legal trouble. We got into what technical decisions shape the legal outcome of a breach, what security choices end up in front of a judge, and what it's actually like to deal with ransomware groups. Ever wondered how the security work you do today holds up when everything breaks? This is the conversation that makes it real. I'm here today with Mike Jervis, who is a lawyer at Mullen Coughlin, and it's going to be a little bit of a different episode today. We're going to talk a little bit about what happens on the other side of migrations. But Mike, glad to have you here.
Great, yeah. Thanks to being here, and thanks for having me.
Cool. So I want to hear a lot about what you see and what kind of work your clients do and why they bring you in. But I guess we've talked a little bit, but give me a little bit of a background on what kind of legal work do you do?
Yeah. So, as you said, I'm here at the firm of Mullen Coughlin, and we are a firm that we specialize exclusively in doing privacy and cybersecurity legal work. So there's a variety of aspects of that, but the core of what we do is sort of what you alluded to, which is dealing with the aftermath of problems. So a big part of what I and the other attorneys here do is basically helping clients when they've had some kind of security problem. Hopefully not always is it a huge disaster, but sometimes it is. Many of our clients are, calling us because they woke up or came in the office this morning and found all of their systems are encrypted with ransomware and they can't access anything and they don't know what to do. That's not always the case. So we do, also have clients who, maybe there's been a wire fraud. So they, got a call from a vendor saying, hey, what's happening with the payment on this invoice that's, 3 months out of overdue or something. They say, what are you talking about? We paid that 2 months ago. And then they look and realize that a bad actor had gotten into their email stream somehow and gotten them to divert that to the wrong place. So, they come to us and they say, how do we deal with this? Is there a way to claw this money back? Are there legal implications? So on and so forth. We help them through that. So there's a lot of that going on. And then, the aftermath of those incidents as well. So I also do a lot of litigation. I have a lot of clients who have one of those incidents. They have to notify people. A lot of those folks listening here probably have gotten one or more of those notices over the years. Possible one of those was written by me. It's not out of the question. And then people, attorneys gather folks and try to make a class action out of it and then sue our clients. And we deal with defending those as well. And also some proactive work. So, many of our clients are, this is prominent. This is not new. These are things a lot of people have heard about. Companies know that this is a risk now. So some of them are coming in and being proactive and calling us ahead of time and saying, hey, what kind of steps can I take to help protect against those things, both technical and legal? What kind of policies and terms can I put in place to try to minimize the risk of litigation if we do, unfortunately, have an incident, and all kinds of things like that.
Awesome. It's the thing I think is most fascinating about this to me is that this is a deeply technical set of problems. Like these are issues that people run into, sometimes, as you mentioned, there's social engineering, like getting into their email, but there's technical causes behind like, how did we get there in the first place? How did you find this line of work?
Yeah, you're 100% right. I mean, there's a lot of technical overlap, and we are constantly on the phone with technical folks, whether it's, experts in litigation, whether it's the firms that come in and do the investigation during, for example, a ransomware event. I come at this from a technical angle and interest in technology. So before I went to law school and became a lawyer, I did tech stuff, for lack of a better term. My undergraduate major was computer science. I did, programming, coding, software development, all that kind of stuff, a little network admin for about 3 years before going back to law school. Didn't immediately start doing this kind of work. I was doing general litigation, but always was interested in the tech side of things and was looking for ways to kind of use both the technical and legal background, and was lucky enough to come across Mullen Coughlin, which, again, focuses in this area. But that said, I'm somewhat unique. There are a few other folks on our end that do have that background, but a lot of the attorneys are, coming from other areas. They did a traditional, history, English, literature, whatever, undergrad, went to law school. A lot of people at the firm were attorneys. I'm sorry, not attorney. Oh, they were attorneys. They were prosecutors beforehand. That's a common path for us. So it's a variety, and it's just, we partner with the technical folks. We learn things as we go. There are many people I work with, I think, that are more well versed in, how a threat actor, moves across the network using various, Windows possible vulnerabilities, things like that, that never thought that's something they would ever be talking about with clients. So, but it keeps it interesting because it's forever changing.
That's the security landscape is vast for sure. Why prosecutors? Is there like a specific skill set or interest that draws them to this?
I think, I don't know if there's any particular reason. I think part of the reason early on, and I will say that's as the firm's grown. So the firm is not quite, it's about 8.5 years old. So it's a relatively young firm. The people who started it before I joined spun off from a larger firm. In the early days, they did bring in a lot of those, former prosecutors. I think there was sort of a mindset that there's the investigatory aspect to it. The same way you're sort of, when you're looking into a ransomware, you're sort of investigating a crime. From our perspective, we're not doing that investigation with the goal of coming, to a criminal prosecution the way the FBI might or U.S. attorney might. We're trying to just advise our clients on, civil obligations and the like. But there's kind of a similar mindset there. Certainly as the firm's grown and we're up to, I don't know, over 125 attorneys now. So there's a lot more variety. But that core group, I think, was attracted to that similar investigatory mindset.
That makes a ton of sense. Just really like go after like what happened here and let's tie the story together in order to move forward.
That's right. Yeah.
Let's talk through an example. I love the idea of a core part of this work being like what happened and what do you know? Can you give me an example of something like a ransomware attack that and what point were you brought in? What did you have to do?
Yeah, absolutely. So, we can happy to sort of talk through what a typical ransomware response looks like. That's, certainly, as you might imagine, one of the most involved. There's a lot happening, right from the beginning. Clients, as I said, are often shut down. They can't do whatever they do, whether it's make widgets, send out mailers, whatever else it might be. They may have clients of theirs knocking down the door saying what's going on. So typically in those situations, we do get involved as legal counsel right away. That's for a few reasons. One is that we retain a lot of the other vendors that do sort of the more technical investigation at the outset. We retain them and make it our kind of quote unquote expert. It's not in litigation yet, but we do consider it to be an attorney-client privileged. So if there were litigation down the line, we would argue that those findings, are subject to that privilege and, are not fully disclosable and things like that. And we sort of quarterback things as well. We know, how these work, what's going on. And, it's helpful to have one person who kind of coordinates all the different vendors, especially when you have a client. They're scrambling internally to do the remediation work they need to do. They don't need to take the time out to have someone be a project manager or anything like that. So sometimes that investigation work, you use the term finding out what's happened, and that's exactly what it is. So we'll bring in a forensic investigator who are the technical folks, and that's exactly what they're trying to do. They're trying to dig in, see what's going on, look at event logs, look at firewall logs if they have them, things like that, and just try to trace back from today backwards what happened, where did we see the threat actor move within the network, within the environment, what did we see them touch, and hopefully get all the way back to here's the first point of compromise and what the vulnerability was, what the hole was that they came through to get in. Sometimes during that process, it is more their show and we're taking a bit of a back seat and just kind of waiting for the results of that, what happens, so that we can then say to the client, okay, based on that, here are the legal questions and obligations. But there can be other areas where we come in right away. So One thing that, is common these days, as more companies are aware of these things, companies will have contracts when they hire a third-party vendor, especially if that vendor is receiving information and data from them or connecting to their network. It will say if you have a data security incident or even just a security incident, you have to tell us within 48 hours. So we have sometimes have clients who are saying, I know I have this contract, especially with big companies. Sometimes we have clients that are maybe smaller manufacturers of goods, and they, are not a huge company, but they are selling through, for example, Amazon or something like that, or through Walmart, big companies that have those standard data protection agreements. So very quickly and early on, they're saying, look, I know that's, Amazon's one of my biggest sellers. I'm going to have to tell them. We know they're going to have questions. Some of them are going to be technical. Some are going to be legal. But we can be the funnel for those questions and help them, with responding and making sure that, the information being provided is accurate. It's, helpful to both parties in a way, but not oversharing in a way that could be problematic. Generally in those situations, it's not like litigation. Our client and their customer client, like an Amazon, is not adversarial. They're just trying to work together to make sure they have the information they need. But you have to be careful because there can be legal implications if you share information that turns out to be inaccurate or it's just too much information or something like that. So we can help them through those kinds of processes. If they're getting a lot of questions, pushback, if it's a client with a large customer base, like maybe a school system, just helping with messaging. Hey, we have to tell all the students, don't come to school today. There will be no point. It basically becomes a snow day because all the computers are down. There's nothing we can do. If that's the case, helping with that kind of messaging, making sure it's done in a legally compliant and advisable way.
Interesting. So 48 hours is not a lot of time to figure out what happened. What are you looking for in those first 48 hours that might make a difference in how you talk with a client's vendor or client's customer base?
Yeah, and that's you're 100% right. I mean, really, it's quick. You don't necessarily know much. A lot of times that first communication is, look, Joe compliance from vendor. We're telling you about this because we have an obligation under the contract to tell you within 48 hours if we experience unauthorized access to our network. We're telling you we've experienced that. We've, retained legal counsel and a forensic investigation firm to investigate. We are investigating. We'll tell you when we know more. And that's really all we can say because there's not much. And that's where, having legal counsel involved early on can be helpful because sometimes the receiving, party, they're freaking out because maybe they're not super sophisticated. They don't know if the ransomware is going to jump to them. They don't know what's going on. They have all these questions and they're pushing for answers and they want our client to give them information or tell them answers to things that we can't answer, not because we don't want to, we don't want to cooperate. We just don't know yet. So it's important to have someone, they're getting pressure from someone who might be an important customer of theirs. And we can step in and say, look, I understand, what you're asking, why you're asking those questions. We've been through this a million times. And I'm telling you, if I told you an answer to your question right now, you wouldn't like it because it's not necessarily going to be accurate. So, and we can kind of say, here's the process, by maybe next week, we'll think we'll have more answers or, a few days we'll have more answers and, help assuage their fears, that they're going to be a target as a result, things like that.
Yeah. Is there anything that you might learn or that you learned in a particular time in the first 48 hours that you did feel like had to go out to a customer in a more unvarnished form?
I don't know if I've ever really come across that situation. I mean, I think, you could imagine if there is, we don't see it much these days for these kinds of reasons. I mean, if there's a direct, VPN tunnel or something between our client and, one of their customers or vendors, that's probably these days, people know about those risks, and could be, they're probably going to be on a different network, different subnet. It's going to be done in a way that's not visible to the threat actor by being on one network, but something like that where there is a real risk of lateral movement to the customer's network, you'd want to give them a heads up about that kind of thing. That's kind of a hypothetical where you might see that come up. Usually we don't have answers about impact to to data at that point. I mean, it's just too quick. Even if you're talking with the threat actor quickly and getting some information from them, that's a criminal sitting, depending, likely in Eastern Europe, maybe somewhere in Asia. They're telling you, I stole 20 terabytes of data, 20 gigabytes of data, whatever it might be from your network. You got to take it with a grain of salt, just like any other, criminal you've never dealt with before, so you don't necessarily want to start shouting that from the rooftops or even, disclosing it to trusted partners without some verification that what they're saying has some truth to it. So there's really very little in that early stage that is really even valuable to share, I would say.
Yeah, that makes sense. At what point, either by time frame or by like type of information, do you generally start opening up with that kind of communication?
Yeah, so I mean, most of it's driven by what the obligations are, right? I mean, and that's kind of a lawyer answer, of course. You won't want to say more than you have to say, and all those kinds of things. So, if you have a contract with a sophisticated third party like that, who's you have to notify quickly, and they're pushing for answers, especially if it's a very important partner of our client. You need to start giving information when you feel like it's accurate and safe to be shared. You share it if they're pushing for it, if our client wants to share it. In terms of, those notifications that go out to individuals that, again, we've probably all received many of by this point.
So many.
Most that's driven by state laws. Each state has a different law about how to notify and when. There are some federal laws in particular areas, HIPAA with respect to medical information, GLBA with respect to banking information, things like that. Those all have different timelines, and it's driven by those statutes. So the goal there is to, usually we look at those laws and say, okay, it says you have 30 days from when a data breach has been identified. Well, data breach is identified not just as unauthorized access to the system, but actual theft of something like a social security number that's protected. So, we'll say, okay, from the day that we, have confirmed that we know that people in this state had their social security number impacted, for example, we have 30 days from that time to notify the residents of those states. And that kind of drives a lot of the timing of that process.
Got it. What are the most, well, let me ask this. It feels like most of the notifications I get are fairly bland, that something has happened and it's not good, but we'll keep you apprised. Okay, sure. I can't do a lot about that. What are the statutes or laws that are the most onerous, that drive the sort of most real disclosure and communication to customers?
Yeah, so a lot of the state statutes are pretty much the same. They've a lot of kind of over the years been modeled after each other. There was some early adopters, and then it took time. The last state to have a notification statute was Alabama, which was, I think, first passed in 2018, something like that. So they kind of, over time, kind of copied each other. California, as you might imagine, is the most specific about what to include. That kind of drives the format that you usually see, because if it's compliant with California, it's probably compliant with almost every other state. So it's just kind of easiest to do it that way. That still is a fairly generic and bland. Most don't require too much detail. Some states, including Massachusetts, for example, restrict actually how much you're supposed to share. I'm not sure what the legislation there was. Don't ask me, but so there can be restrictions. I mean, the idea is that people will start freaking out if they you overshare, you think there's more, so you want to just kind of comply with the statute, give them what they need if they want to, enroll in credit monitoring or something like that, take a look at their bank accounts. The reality is at this point in 2025, our information is out there. Your social security number is almost something in the dark web. I'm sure mine is. It's unfortunate, but true. So while it's, I understand the legislative scheme behind these notifications, giving people a heads up to keep an eye on their accounts. The reality is any one data breach really causing any more risk to your information than, it's already out there? Probably not really.
So I just post my social on the dark web just to get ahead of it.
Yeah, that's right. I always think the same thing. It's, sometimes we get these lawsuits that people are complaining. I was like, Well, first you said you don't want it out there, but then you say you have anxiety because it's out there, and which is, did you want us to tell you or just not want us to tell you?
Yeah, take the power back. So what, shifting gears a little bit, what drives this kind of thing? Like, what are the underlying technical vulnerabilities that you see that drive these kinds of ransomware or data access or data theft breaches?
Yeah, so it really can be any of the kinds of vulnerabilities that you would think of, and they evolve over time. When I first started doing this work 5 years ago, a lot of ransomware was still, RDP over the internet, no lock on, none of the timeouts on logins. So you could credential stuff or do brute force. That's a lot harder these days. Most companies are protecting against that. So it's, some of it's not necessarily 0 day, but relatively recently identified vulnerabilities in a VPN or firewall appliance, something like that. A few years ago, there was the widespread exchange vulnerability for, on-premise. People were still using the on-premise exchange solution rather than M365 in the cloud. So those are common, and people are not always great about patching or aren't good at keeping up with what the CVs are that are out there so that they're aware of the patches. So that can range anything from a 0 day to, it may be months or even a year down the line that we find clients that still haven't patched for, again, that kind of firewall, hole that may be out there. And, threat actors are just out there just randomly scanning, the internet and seeing what they can find. There's still a human error element to it as well. That's more common in the email compromise world. So, phishing schemes are more likely just to be targeted at getting access to your email account and try to do something nefarious. But it can be a source of ransomware as well. Attachments that, say, where's this invoice? It hasn't been paid. And, what's going on? So someone gets nervous, double clicks it. It's not actually an invoice from their vendor. It's, malware that gets downloaded and creates a backdoor. And then, threat actors are sophisticated. Once they have a foothold, they're pretty good about, getting around. A lot of times we see Cobalt Strike deployed, which is, a tool used by security researchers, but also used by the bad guys to, once they're in, create all kinds of backdoors, get a foothold. It's not uncommon for these threat actors to get into a system through one of those vulnerabilities and be sitting there for days, weeks, even a month or two, kind of just seeing what's going on, seeing if there's anything interesting happening. They can exploit, trying to figure out what data is there, what might be the most, valuable data to exfiltrate before they actually, deploy the encryption. So there's all kinds of tools they use to maintain persistence before they actually launch the attack.
Interesting. How have things evolved over the last 5 years? You said you were seeing different attacks.
Yeah, so I think the two big ways that you see things changing or evolving are what we were just talking about. It's a cat and mouse game. They come up with a scheme, a vulnerability to exploit. Companies realize that, they patch it. RDP is not available over the open internet anymore. You have to be on the VPN or the local network, or there's timeouts. 5 wrong passwords are timed out for 5 minutes. Makes brute forcing faster. They come up with the next thing and the next thing and the next thing. It's like anything else. It's a cat and mouse game. The other big evolution, particularly in the ransomware side, is that exfiltration. So again, when I started doing this work, in some ways from a legal perspective, ransomware was, if you have to get hit with something, it's much better at ransomware because they come in, they'd encrypt everything. It would suck, but you'd either have your backups or you'd pay for the key and decrypt it, and you'd back up and running. Legally, nothing came from it. As companies started, again, evolving, protecting against that by having better backups, by having offline backups that couldn't be encrypted, threat actors weren't getting paid because people were like, why am I going to pay you for a decryption key when I can just restore from my backups? I'm good. That's when they started doing the data exfiltration. Before they run the encryption, they take all kinds of stuff out. From a legal standpoint, that puts you at much more risk because now maybe they have taken those documents, files, whatever, that have social security numbers, have medical information. You need to start notifying people. And so now they're holding that for ransom as well. The threat actors are saying, well, you should pay me because you'll get all of your information back more quickly. But also, I'll promise that I'll delete this information and I won't post it on the dark web if you pay me. So they're trying to extort you for both reasons. And they don't really care which one motivates you more to pay or not, as long as you pay. But that's kind of their dual scheme. And now we even see there are some threat actor groups that don't even bother with the encryption. They feel like no one's really paying for that anymore. Everyone, it's low payment rate on restoration of data. So they just come in, they take all of your stuff. You don't even realize anything's wrong. And then maybe a few days later, you get an email from some Proton Mail account saying, hey, IT director, I have all your stuff. Let me know if you want me to prove it. I'll show you the file tree, proving that I was in your system. If you don't want me to post it on the dark web, it costs you 30 Bitcoin or whatever.
Huh. How do they... Okay, if I got that email, I absolutely would not trust that they would delete the data or not prove it. Sure, they could send me things to prove that they have the data, but how do you build the trust with a criminal you just met that they're actually going to delete your data?
So it's interesting. So there's two answers to that. The first one is you don't really, you can't really trust that. I mean, we always tell, and anyone, advising about these things tells clients, it's great, maybe they delete it. Do we really know? Are they keeping a copy? They might be, there's really no way to know, for sure what's going on there. The sort of more sophisticated or, detailed answer is it's strangely enough, and this is one of the most interesting and oddest things about the ransomware ecosystem, is that it does basically operate like a legitimate business and a legitimate, line of business, except for the fact that they're, getting unauthorized access to your computer system and committing a crime to do it. But they have,
this crime.
Yeah, these are sophisticated groups. They are known groups. So there are certain ones that we know them by name, or, the name they go by, or, Microsoft Security Research gives them a name or whatever. So they do have a reputation. So they know that if, they get paid to not post on the dark web and they post, no one's going to pay them in the future. They have a reputation there, a known one. And, that these groups come and go, and sometimes they get either law enforcement does get to them, or if for whatever reason they fall apart and they reformulate, and you can kind of tell it's probably related to the same group that was there before, but they do have that reputation. And so at least if you pay, you can feel fairly confident you're not going to get posted on the dark web. That doesn't necessarily mean that they've deleted everything. They may still have a copy sitting there in the background. I'm not sure how that maybe just out of, them not really being that robust about keeping track of what they've deleted and not. You probably won't get posted, but they are very, again, they operate like sophisticated business entities in every way, except for the fact that they are it's kind of like a large, drug cartel or anything. What they're doing is illegal, but the operation is actually buttoned up and sophisticated. They have, one person who is the trained negotiator, and that's who negotiates with you if you're going to pay. They might say it's 30 Bitcoin to get your data deleted. You might say, I can only pay 1 Bitcoin, and you go back and forth till you get something. They have a whole other department that's basically customer support, IT support. If you pay for the key and you get it, and it's not working for you for some reason, they have their tech people that will work with you to try to figure out, maybe it was because they didn't properly shut down your database daemon process in the background before they encrypted. So they'll help you figure out how to undo that, or, whatever it is. They will literally come in just like they're Microsoft or whoever and help you, troubleshoot the problem with the key.
That's amazing. I wonder if they keep, they keep like net retention numbers, or they keep customer satisfaction scores on the back end, right?
They might be. I don't know. They do. They like to act, similarly funny. They act like they are a service. They're helping you. They refer to victims as customers. They often I don't know what they say to themselves, but outwardly they talk about how they're providing the service where, they help you identify your vulnerabilities so you can patch them up before someone else comes in.
Sure.
much as though they were a pen tester that you have proactively hired to do that. So it's an interesting ecosystem.
How much? I mean, that level of reputation requires a certain amount of awareness of the groups. Are are the same groups working with the same clients repeatedly, or is it just a industry wide? Friends talk to friends at different companies.
Yeah,
Kind of reputation.
it's more the latter, and some of them are rivals too. We have seen there's been times, again, just like any other organization, as much as they might try, we have seen times where there is infighting, and people that are leading one group disagree with each other, so they splinter off, and then it's an interesting insight sometimes. One group will break off, they decide they're mad at the leadership, so they create their own group and they leak details about internal, strategy or whatever at the old group they left. So some of them are rivals, and things like that. But, just like anything else, it runs the gamut, from everything. I mean, the forensic folks and the security researchers at places like Mandiant and CrowdStrike and Microsoft and everything, Google, they're doing research independent of any one incident, and they find ways to try to fingerprint them, and they can sometimes say, geographically they can put some level of specificity on it, not too specific, but they'll see that, there was metadata left behind, that they were using a Cyrillic keyboard or a Mandarin keyboard that gives you some sense, or little things like that. Just little behaviors that, again, they could see when maybe one group that splinters off is related to a previous one. They're always trying to stay ahead of the U.S. government, not just, law enforcement, but also there's the Office of Foreign Asset Control, which, creates penalties if you pay a terrorist group. Sometimes if some of these groups are, the security researchers do enough to affiliate them with a country like Iran or North Korea that, there's sanctions on doing business with, you could theoretically be paying a terrorist group by making a ransom payment. So when that happens, they know they're not going to get paid anymore. So they try to spin off into another group and rename themselves. So there's all kinds of things like that going on.
Interesting. So there's almost this is the working with the product and distribution of these companies a part of how you advise clients? You can't work with this company. They're in a sanctioned country. That's illegitimate business.
Yeah, that's definitely part of it. Before any ransom payment is made, an OFAC, an Office of Foreign Asset Control check is performed. That's not done by us. That's done by third-party payment companies who actually do the Bitcoin exchange. I can't tell you exactly what they look at, but sometimes a threat actor group just is known, and if you get hit by that group, we have to tell our clients, I'm sorry, but there's no way you can make a payment here. They check other fingerprints. Bitcoin wallets, if the Bitcoin wallet's associated with a group that's sanctioned, they won't make a payment to that wallet. Things like that, other known fingerprints. But, that's all part of it. You have to be careful to make sure you're complying with all kinds of rules and regulations. So, that's definitely part of the process.
It's a whole industry.
It really is. It's kind of funny. It would be funny if it weren't so sad and disrupting, so many businesses, but if these folks, actually put themselves in some kind of legitimate, industry and spun up some product, they could probably make a lot of money without being worried about being chased by the FBI and Interpol and all those entities. But
how much does it cost to pay for pen testing post hoc instead of proactively?
Yeah, so the cost of the forensic investigation when you've been hit with an incident is really going to vary depending on the size of your network and things like that. They're going to pull logs and artifacts from pretty much every server in your environment, so, and maybe some of the personal computers as well. So, if you're a small, solo CPA office and you just have kind of one file server and a couple people with laptops and that's really it, it could be, might not be that expensive to do the investigation. If you're a large company with a wide network, all kinds of file servers and appliances and this, that, and the other thing, say on FTP server, anything like that, it's going to get more expensive. Either way, I would say it's going to be less expensive for you in terms of money and time and headache if you hire a pen tester now and try to find out what holes you have and start plugging them up rather than waiting for a very, benevolent threat actor to come in and do that pen testing for you involuntarily.
It's basically charity work.
That's right.
Makes sense. Okay, I want to talk a little bit about the litigation side of things as well. So you mentioned earlier that when a customer does suffer one of these breaches, they do the notifications, and sometimes customers get mad enough that they decide to band together and sue. What kind of problem what tips the scales on that? Is it the severity of the breach? Is it the type of industry they're in? What will cause a customer base to decide that that's the right path forward?
Yeah, so I think I used to say, as recently as 6 months ago, there's basically two things that drive the likelihood of a class action litigation following on an incident. The first is just the size of the impacted population. The more people there are, the bigger the potential putative class is, the more money there is to be made for a plaintiff's attorney. So they focus their energy, as you might expect, on ones where they think they can make more money. And this is driven by the plaintiff's attorneys. They try to recruit plaintiffs. It's much less about a person getting a letter, being mad about it, calling whoever advertised on the side of the local bus or billboard or something. That does happen, but it's much less about that versus these attorneys who are, really focused in this area and do almost nothing but plaintiff side data breach litigation. They try to advertise for specifically people who have gotten one of these letters from a particular breach. There's ways they find out about them and advertise for them. But again, so it was, they focus on the big ones, and then to a certain extent industry. So, healthcare entity, maybe is a bigger target. It's easier to perhaps build a narrative about how bad it is for healthcare to let it leak out that, maybe some of these people have HIV positive tests there. Maybe some have cancer diagnoses that are sensitive or whatever else it might be. So those kinds of things would drive it. The severity of the breach, it's much more likely to happen, or historically has been much more likely to be sued after a ransomware incident, but largely because those are the ones that are likely to result in a larger population of people because they're just pulling gigabytes and gigabytes out of your systems versus one email account they have access to. That's changed. A lot of these attorneys have pivoted to be willing to take on smaller cases, which much smaller groups of people. So that's perhaps less of an impact. Severity of the breach in terms of, how, for example, how bad or not the vulnerability that was exploited was, how much awareness the company should have had that, they should have patched this or, fixed this hole, whatever it is, doesn't really come into play because frankly, no one outside the company and their, investigation team really knows the answer to that until after the fact. If they do get sued and that gets into discovery and you start doing that exchange of information, then that might be come out. But before the complaint's filed, before the litigation is initiated, that information really isn't out there.
It was a breach. The data is out. How you handled it and how effectively you handled it make it worse way down the line. Exactly.
If you asked one of my colleagues that practices on the other side of the aisle that represents plaintiffs, they would tell you that, well, if a breach happened, it must have been bad security. There's no, which, I think obviously we take the position that's not true. And even the most sophisticated buttoned up companies like a Google or Microsoft can have, for one reason or another, an incident, but they're going to take the position that they feel pretty strongly that if a significant, breach of information happened, they must be able to prove somehow that there was inadequate security.
Interesting. You said that until as recently as 6 months ago, this is what you would say. Has something changed?
So all of a sudden we have seen this uptick in plaintiffs' attorneys willing to take on cases with much smaller classes, 500, 1,000 people. Used to be, it had to be at least 10, 15,000 for them to feel like it was worth taking on the litigation. But that's just a trend we're seeing. I couldn't really tell you. There's not been a change in the law or anything like that I see that prompts that. It's just, I don't know, if there's different reasons for it. in their thinking, but that's just a trend we've seen that doesn't seem to be prompted by anything in particular.
Interesting. It almost sounds like they're getting more efficient. Like they can handle a higher caseload and take on lower yield.
Yeah, I think there's probably some truth to that. We have seen these cases can be handled pretty efficiently. What you'll see, if you're a lawyer, anyone listening to a lawyer goes out there and searches for cases on Westlaw, things like that, you'll find these cases. There's really, as far as I'm aware, there are 0 that have actually gone to a trial and had a jury reach a verdict. Even beyond that, only a handful that have gone through that discovery process and had a judge decide about class certification, which is when a judge says, yes, this can be a class action, or no, it cannot. Had a judge rule on summary judgment, which is when you say to a judge before trial, we have all the evidence, we think that there's no fact questions in a matter of law, we win, kind of thing. A few have gone that far, but that's it. These tend to settle early. Sometimes a motion to dismiss is filed, which is basically when you're saying, based on the complaint they've filed, even if everything the plaintiff says is true, they still lose, even if they could prove that. And then, if cases are not dismissed at that stage, there's often a settlement, and that's for a variety of reasons. But as a result, it is somewhat easy on both the defense and plaintiff side to have a fairly large load of those cases, because the heavy work comes when you do get into discovery. There's a lot of documents to be reviewed, things like that. We sense a trend that's going to be changing soon for a variety of reasons, that more of these will be litigated and defended. So that's going to make it harder, again, for attorneys on both sides of the aisle to, handle as many cases. There's just so much more work to do when you take them that far. But for right now, they are resolving early, so it's possible to have a wider load for those plaintiffs' attorneys.
Interesting. What do you see come out during discovery that is either that's most impactful when you actually get to that stage?
So it's been so few of them have gotten that far that there's still a lot of guessing going on amongst lawyers, on both sides of the V. But there's a few things that I think are going to be crucial, as more and more of these get investigated that far due to discovery. I mean, obviously, like we were talking about a few minutes ago, how the incident happened, what was the cause of the security incident, it was going to be a big factor. If you were exploited and you suffered a ransomware because someone attacked a 0-day vulnerability literally on the 0 day, and you had no knowledge of it, and there really was nothing you do yet to patch because there's no patch out, that's going to be a lot harder, I would think, for a plaintiff to argue, well, you had insufficient security. On the other hand, if you have an email account and you still are not doing basic, protection on that account, are still doing some of those vulnerabilities that were exploited 4, 5, 6 years ago and have now largely been identified, that's going to be a stronger thing, a stronger argument for them. There's just going to be a lot of, much like anything else. So, I used to do, for example, work in construction accidents, a catastrophic accident on a construction site. And there would always be a lot of digging into, not just what led to that specific accident, but what was the general safety posture on the work site. Were there weekly toolbox talks reminding people about certain safety things? Were people written up if they were not following the safety protocols? All those kinds of things are probably going to be what's going to be looked into here and scrutinized, but with regards to information and technical security within an environment.
What do you think? And I'm thinking sort of as advice for security professionals here. What comes out, or what do you think will come out in litigation over the next few years that indicates a robust security posture versus just theater or laziness?
Yeah, I mean, I think from my perspective, and to loop back to where we kind of started, you have to take this with a bit of a grain of salt, because while I do a technical background these days, I'm the legal person and not the technical person. So, someone who is actually a pen tester or a forensic investigator can probably give you a much more detailed thought. But, from my perspective, from a technical standpoint, the sort of A+ answer is, you have a robust EDR tool deployed on your network, a Sentinel-1, for example, with, 24/7 monitoring. It's not just sitting there and you're waiting for alerts. Someone's monitoring it, looking for anomalous activity, identifying it right away, that kind of thing. And then just doing your regular, at least annual pen testing, just kind of going through that, that process to make sure that you're doing that. Obviously as a lawyer, that always makes me nervous too, because you're creating a list for yourself of what you're not doing correctly, which then if something did happen, you got sued, a plaintiff's attorney could get their hands on. But if you really want to be proactive, it's probably the best practice, and just, make sure you're doing everything possible to address any vulnerabilities identified as soon as they're there. The other big one that comes up a lot is that training. A lot of folks that work at larger companies are probably used to the occasional, fake phishing test that you get from your IT department, and they're looking to see if you click on it. And if you do click on the link, you get a pop-up that says you failed the test. It's annoying, but it's a good way to keep everyone's, sharp. And you could say to someone, if you did get sued or something like that, hey, we're doing these things, and there's always going to be human risk. I mean, people are never going to be perfect, but the more you can say, hey, we were training, we did our best, people who failed got retrained, that kind of thing. Just showing that you're on top of it. What the latest trends are. You're doing what you can. Again, I think it's nonsense to say that just because an incident happened, things were substandard. Even the most buttoned up companies, things happen. The more you can just say you're on top of it and I was doing my best, the better off you're going to be.
That makes sense. Where do you see the impact of kind of the work of patching and upgrades creep in? Because that can be a big part of it. Is either you own the software and you wrote it, or you don't own the software and you just need to keep it patched. Obviously the right answer here is you keep everything perfectly up to date, but people don't do that, so there's reasons. How do you see folks navigating that, and where do you think that they could do better?
Yeah, so it's like you said, I mean, the best answer is you're always aware of it. You're daily checking, CVEs and new patches and everything, and getting those rolled out. Like you said, that's not always possible. Certainly in the world I operate in, it's a little bit maybe adjacent to what you deal with upgrading and patching your own software. I'm dealing with clients who are trying to patch third-party appliances, software, etc. It's crucially important to stay on top of it for sure. It is kind of, as applies to so many things, there's the old metaphor about the bear. You don't have to outrun the bear, just everyone else, or at least one other person. There's some truth to that. These threat actor groups are looking for the low-hanging fruit. Most of them are not trying to, put their flag on Mount Everest by getting into Microsoft's most internal servers. They're here to make money. They want to find an easy target and go for it. So there is an extent to which, if you're kind of just staying on top of the most things, you're making sure Microsoft Patch Tuesdays are rolled out, assuming you're using Microsoft, environment, things like that. As long as you're kind of staying ahead of the curve and you're not, behind, again, the solo CPA practitioner who has no IT support, that's going to put you ahead of a lot of people. Doesn't mean you're going to be foolproof, but again, if you're not the lowest hanging fruit, you're somewhat less likely to get hit by one of these threat actor groups. From my, well, I guess that's probably about right on the patching side of things. It's just, again, doing your best, not falling behind, making sure you have sort of a regular schedule where, again, maybe you don't have the patch from this morning quite yet, but you have a regular schedule. You at least are aware of it and staying on top of things.
Yeah, it's hard. It's hard once you've fallen behind to try and maintain any kind of regularity. And I think that aligns with a lot of what we see in the first party. I own my software. I write custom software kind of world, is that the real trick is not to be perfect. It's all about where can you make the biggest impact? Can you understand up front what needs to be done, and then pick the stuff that's really going to work and you have high confidence is going to get to the end. Like no sense in trying to pull in an update that isn't ready for your environment and has failed other people. Like go get the other 7 things that you should have done 6 months ago.
Yeah, absolutely. And it's, the threat actors are watching the same, tech news sources that we all are. So when it's something that's a widespread, issue, the Crush FTP vulnerability that came out recently, it was in the news. SolarWinds, when that was in the news a few years ago, big ones like that, hit that right away because the threat actors see that and they're going to be trying to hit as many of those as they can before people get patched. Big system-wide things like, Microsoft Windows vulnerabilities, common firewall appliance, firmware, make sure that you're updating that because those are things threat actors will look in. They don't want to reinvent the wheel. They want to find stuff they can exploit over and over again. To your point, the smaller, somewhat more niche software you're using that's niche to your industry or something like that, maybe there's somewhat less risk there. You should certainly be trying to, keep that updated and patched as well, but, maybe there's less risk with threat actor exploiting that sort of more unique software product or appliance.
Makes sense. Cool. Well, before we wrap up, want to do a quick fire round.
All right.
So one question, first thing that comes to your mind.
Right.
If there's one technology you could wipe off the face of the planet, never existed, what would it be?
Ooh. I'm not being very good at quick fire here, but I mean, well, it would basically stop everything, but if we didn't have any networking, we wouldn't have any vulnerabilities. So, if we go back and get rid of TCP IP, 40, 50 years ago.
The problem is the internet. That was a mistake.
That's right.
We probably shouldn't have. I love it.
I do have clients who say, they wish they're fine with, they'll take the ransomware risk. They wish we could just go back to snail mail though, and not have email, at least avoid the email compromises and the wire fraud. Sometimes I have clients and partners that say that. So
I get it. I've been reading Calvin and Hobbes with my kids recently, and Calvin's dad complains, these telephones, they make everything so urgent. It was great that you used to be able to write someone a mail and you knew you weren't going to hear from them for a week.
Yeah,
and
you had some time.
Maybe that's the world we want to live in.
It wouldn't be the worst thing if we weren't getting, 20 emails a minute popping up in our inboxes.
Absolutely. What is the weirdest technology choice you saw at the center of one of these incidents?
Just generally I'm going to cheat a little bit by not naming one, but I have seen people with the most legacy, I'm talking 80s, 90s type, whether it's a database platform or sort of a content management system, way pre-WordPress that they just refuse to bring into a more modern solution. It causes headaches because I don't know that it's not any more vulnerable, but if you do have a problem, no one in the world knows how to fix it or, figure out what happened, do the investigation, things like that. So if it's okay to give you a broad category, that's what I would pinpoint is a few times I've had that where we bring in forensic teams and they're just like, I don't even know what to do with this. Exactly.
I'm so sorry. I love that. If there's one piece of advice you could give the security professionals that you work with broadly, what would it be?
Know where your data is. So we talked a lot about the security stuff, and this is, I guess, maybe not really a security thing, but that is one of the biggest things where we see people get into trouble is someone gets in, they have a ransomware, and they say, well, that's not fine, but we're not going to have any legal issues. We don't need counsel because there's nothing on that server. I mean, no, it's just, a bunch of spreadsheets of our financials and nothing about that. And then 3 months later, they call us and say, oh, actually, we do need counsel because we looked into it and there's a spreadsheet that someone for some reason put in there that has the social security number of everybody that has ever worked at this company over the last 25 years.
Just little details like that.
You can never be 100% on security. You can do very well as with all the things we were just talking about. But if you do get hit, you could be a lot happier if you know that actually we enforced data retention standards, things were deleted when we didn't need anymore, and we kept it all segregated to the place it's supposed to be.
Know where your data is. That's the starting point. I love it.
Absolutely.
All right. And last one, where can folks find you on the internet if they have more questions?
So you can find me all over the place. Professionally, the most direct way to get at me is, or to find information about me, and my contact info is at our website, which is just mullen.law. You'll find my profile there. You can, find my email, phone number, etc. there. I'm certainly, you can find me on LinkedIn, just under my regular name, Mike Jervis. Other social medias similar. I'm not super active on Twitter or X, whatever we're supposed to call it these days, but you can find me there as well. So pretty much everywhere I'm under my last name. It's not so common that I can't still get handles under Jervis. So Jervis, you search that, you'll find me.
Lucky. May we all have such unique names in this day and age of unique handles.
Yeah, I come across Jervises and Jarvises. Everyone wants me to be a Jarvis. That's what I get all the time, but it's with an E.
Of course.
So if you're actually looking for me, it's with an E.
Awesome. Well, thank you so much for being here. This was an awesome conversation.
No, it was a lot of fun. I appreciate you having me, and hopefully this brings some valuable information to somebody.
I'm sure it will.